everyone. Thank you for joining us today for Constangy's webinar, Navigating the Digital Frontier, Employee Privacy Rights and Legal Obligations in the Modern Workplace. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please feel free to email Sarah and Ashley following the webinar. Their contact information will be included in the follow-up email. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Ashley and Sarah.
Thank you, and thanks for joining us today for this webinar. As you'll see from the agenda, we have a lot to cover, so we're going to dive right in. We're going to provide an overview of employment and data privacy laws in the U.S., and then we're going to dive right into a few of the more thorny areas in these laws, including biometric information, privacy disclosures, artificial intelligence, and employee surveillance. And we'll finish up with a few key takeaways and practical tips for companies on how to improve data privacy and address employee privacy rights. On the next slide, we'll quickly give some introductions. My name is Sarah Rugnetta. I've been practicing in the area of data privacy and cybersecurity for over 15 years now. I started my career as a regulator, and then I worked as in-house counsel, serving as a privacy officer. And for most of my career, I've had the opportunity to advise in-house counsel on how to navigate complex and very much constantly evolving state, federal, and international privacy and security laws. Ashley, do you want to introduce yourself?
Thanks so much, Sarah, and I'm so thrilled to be here today. My name is Ashley Orler. I'm one of the employment law partners here at Constangy, and I've been in the practice of employment law for over 15 years. I really enjoy advising businesses on the ever-changing laws, regulations, and case law that comes out pertaining to employees, including this area of employee privacy, which seems to be changing on a daily basis. And I also help employers when, unfortunately, there is litigation resulting from employment of employees or anything related to the hiring of employees.
Thanks. So you'll see, as Ashley mentioned, she focuses on employment law. I focus on cybersecurity and data privacy law. This really is an area that does often require analysis of both of these different types of laws. They intersect quite frequently, and this is why Ashley and I are both participating on this webinar and why our groups actually work together when providing advice to clients, especially around data, around employee privacy laws.
And I would just add to what Sarah said, you know, what we're seeing on the employment side of things is more and more jurisdictions are passing laws to protect the privacy of employees. Of course, we're going to talk a lot more about that today. But because of this and the intersection of what Sarah does and her expertise, I'm finding the need to reach out to folks like Sarah to help our clients navigate these ever-changing laws.
So on the next slide, I'm going to, for a couple of slides, talk a little bit about the sort of where we are in the U.S. in terms of data privacy and cybersecurity requirements, give a little bit of context and set the landscape. And then Ashley's going to talk a little bit about where we are with employment laws. So on this slide, you'll see that there's a number of states that are shaded darker blue. These states have passed comprehensive data privacy legislation, and 5 of the 15 states that are in dark blue are already in, those laws are already in effect. The 10 other states that are dark blue will go into effect in the next couple of years, many of them in this year, 2024. I can 100% confidently predict that this slide will change over even probably the next few weeks. For example, just yesterday, we shaded in Kentucky and Maryland because these states just in the last week or two passed comprehensive data privacy laws. I also want to point out that there's a few states that are lighter blue, and those states have more narrowly tailored privacy laws, generally either because the definition of private information is a little bit more narrowly tailored. For example, in Illinois, there's a law that we're going to talk about today that's called BIPA, and it focuses on biometric information. So that's one of the more narrowly tailored laws that we don't consider comprehensive. Or some of the states like Florida apply to a smaller subset of businesses. So we've shaded that lighter blue as well. Those darker blue states, those comprehensive laws, are generally quite broad in scope. They apply to personal information very generally, defined incredibly broadly to include information that identifies an individual or that can be used to identify an individual. And that can include emails, mailing addresses, IP addresses, race, sexual preference, some of the traditionally more sensitive areas of information as well that are covered by breach notification laws in different states, like social security numbers and biometric information as well. So it's a pretty wide range of information. And a lot of times companies are quite surprised to hear how broad the data sets that are protected by those laws. On the right, you'll see a few of the federal laws. Many of these laws apply to specific industries like healthcare and finance for HIPAA and GLBA. Some of the laws apply to specific categories of information or types of consumers. We'll see likely some changes on the federal landscape as well. There is a federal comprehensive privacy bill that some are predicting might be able to move. So we'll see. For sure, though, this particular slide will likely change in the next few weeks and definitely next few months. So moving to the next slide, out of those 15 state comprehensive privacy laws, today we're going to focus a little bit more on California's data privacy law. And this is because the California Consumer Privacy Act, or the CCPA, applies to employee data, which is our focus today. It also applies to business data, B2B data, which in both of those respects, California is much broader than the other 14 comprehensive data privacy laws, most of which carve out employee data. And so you don't have to focus on it as much when you're looking at employee data, although of course, you know, the first step is really to understand which laws apply to you. So you really do need to sometimes take a state-by-state analysis of which laws apply to you. California's threshold in terms of, so on the next slide, you'll see the different thresholds that apply that you need to look at when you're determining whether the CCPA applies to your business. Generally, you're looking, you know, for most of the states, you're going to look more at how much the volume of personal information that the business is collecting either through their website or as part of their business from residents within each state. Oftentimes, the volume of data that is required under each state varies. Sometimes it's as low as 35,000. Oftentimes it's 50 or 100,000 consumer data. In California, the threshold is quite expansive because it also takes into account a company's annual revenue. And in California, if a business has an annual revenue of $25 million and they're doing some type of business in California, which is a pretty low bar that most businesses do meet, then the CCPA may apply to you. You know, and that you don't necessarily need to be headquartered in California. You don't necessarily have to have any employees in California, and the CCPA might still apply to you. There are certain carve-outs. Nonprofits are carved out of the CCPA. There's, you know, other, you know, data-specific carve-outs like protected health information. So, you know, you really have to kind of look at the law specifically, but this is the general threshold. On the next slide, we're going to kind of talk about some of the requirements of the CCPA, some of the more significant requirements. Many of these are also requirements under the other comprehensive state privacy laws, but again, we're focusing more on California today. I'm not going to go into too much detail, but I do want to touch up on a few points. First, and relevant for what we're talking about today, the CCPA requires businesses to post privacy policies that describe how they're collecting, using, and disclosing personal information, both via their website when people visit their website, or as part of their business. And that, because California includes employee data within the scope of the CCPA, it's also required that you issue employee privacy notices that cover the same information, the categories of information you're collecting, a lot of which you're collecting because that data is required to be collected, under different employment laws, like, for example, the EEOC. And that needs to be disclosed to employees, as well as information about how you're using it, the purpose for collecting it, who you're disclosing it to, and different data subject rights, which we're going to cover as well, need to be articulated in those policies. Often businesses have a separate applicant privacy notice as well, because they're collecting a lot, much less information about applicants. So they decide that it makes more sense to have a separate applicant privacy notice. In addition to those notices, the CCPA requires companies to include specific provisions in their contracts with third parties, really around how data is going to be kept confidential, whether it can be used for any other purposes, who it can be disclosed to, and a few other specific requirements for contracts. If they don't have those provisions in contracts, then those third parties will not be considered service providers. And you'll have to make some additional disclosures to your employees and consumers, and oftentimes have to provide a right to opt out of that sharing with third parties. Another important requirement is data minimization. Most companies in the US have historically focused on, especially when they're putting together those data document retention and destruction policies, oftentimes the focus has been on the minimum number of years that certain types of records need to be maintained. Data minimization requirements really kind of turns that strategy a little bit upside down. You still, of course, need to be cognizant of minimum requirements, but you also need to figure out how to, what information you don't need to have, you no longer have a legitimate business purpose or legal purpose for, and then identify and document and implement procedures around destroying the data that's no longer needs to be maintained. On the next slide, I think Ashley's going to talk a little bit about some relevant employee privacy protections.
Thanks so much, Sarah. As Sarah just gave a nice overview of the CCPA requirements, that's a nice example of a very broad protection of employee personal information. So when we're talking today about employee privacy protections, we're covering a wide range of different types of employee data. Here, starting with personal information, laws like the CCPA are being passed to protect, the type of information that all of us would think of as somewhat confidential, our social security numbers, et cetera. There's also more and more legislation being passed that pertains to protecting employees' legal conduct on and off duty. We're not going to talk a ton about this today, but I really wanted to mention that this is an area where we're seeing a lot more legislation and eventually litigation over. And what I mean by on-duty conduct, of course, we're talking about, employees' rights to do certain things while working. For example, the National Labor Relations Act protects employees' right to discuss the terms and conditions of their employment while working. So that's on-duty conduct that's being protected. Off-duty conduct, we're seeing a lot more legislation over In Illinois, for example, we've had a long-standing law that protects employees' right to engage in political affiliations, and employers cannot take adverse action against an employee when off duty that they're exercising those rights. Another great example is we've got two brand new laws in California and Washington that now protect. California's law protects employees. Washington's law protects applicants if they're legally using cannabis outside of work. And those protections include drug testing. So, for example, the California law that just went into effect January of this year prohibits employers from taking adverse action against an employee if they test positive for non-psychoactive cannabinoids. What does that mean? Most of the drug testing that employers are doing in California are using urine drug tests. And therefore, that drug test, that particular type of drug test for cannabis, actually does detect the non-psychoactive. So an employee may not be actually high at work or when that test is conducted. And under California law, using that particular drug test and making an adverse employment decision based on that is now illegal. There's certain exceptions, of course, but it's worth noting. Moving on, we're going to talk a little bit more today about workplace surveillance. Oh, go back to that slide, please. I'm sorry, that was confusing. We're going to talk a little bit more today about workplace surveillance and laws being passed to prohibit employers from doing certain things to monitor their employees while working. We're going to talk a bit about biometric information, health and genetic information today, and also employment records. The one thing before going to the next slide is what you're going to see today is these laws are being passed in a lot of different jurisdictions, but there's a lot of variety in these laws based on which state employees or businesses are operating in. And also there's some variation here about the type of business. There's exceptions to some of these laws based on certain industries that the business are in, whether or not there's other laws in place that kind of preempt those laws. So just something to keep in mind. Please, on the next slide, we can start talking about biometric and genetic data. This first area of biometric information is really, really exploding. We have a number of states that are now passing laws that protect, and it's similar to the California Consumer Privacy Act in that it's not just focused on employees, it protects consumers, but we obviously want to talk about the impact on employees today. Biometric information, how these laws define it, are generally talking about the unique physical characteristics of an individual. So we're talking about things like an individual's fingerprint, their handprint, a voice print, retina scans. We're not talking about photographs or, general, videotaping of for security purposes, like security cameras that don't capture somebody's kind of physical characteristics. We're not talking about kind of physical descriptions. So, for example, if you've got EEO data where you're kind of identifying folks by their gender or race, that is not biometric information. So these laws are being passed increasingly, and on the next slide, we're going to talk in a bit more detail about a law that I'm very familiar with because I'm based here in Chicago, Illinois, called the Illinois Biometric Information Privacy Act. And the reason why we want to highlight this today is for those of you who are not familiar with this law and do have employees located in Illinois, or you are doing business in Illinois, maybe you don't even have any workers physically in Illinois, but you're doing business in Illinois, this law will likely impact you. And we want to make sure that folks understand what this law is and the potential significant impact that this law can have on your business. We call it BIPA. So BIPA requires written notification and assigned release in advance when a business collects, stores, uses, or sells biometric information. So again, we're talking about those fingerprint scans, for example. And the written notification has to have certain requirements in that document under this law, including that the business provides how long the data is going to be stored for, so a retention schedule. We have to provide guidelines for when that data is going to be destroyed. Also, the purpose for collecting the information in the first place. That written notification also has to be made publicly available. So all the time we're helping our clients create notifications that will be put most likely on their websites, right? That's an easy way to publicly disseminate information as required by this law that complies with the requirements here. What is very fascinating about the Illinois BIPA law is it allows a private right of action. And we are dealing with many, I'll say an explosion of class action lawsuits here in Illinois by individuals who are claiming violations of BIPA. Part of the reason why class actions are lucrative under this law is because the statute builds in penalties for violations. The statute language builds in a penalty of $1,000 per violation if it's a negligent violation. So kind of not intentional, a lot of employers don't even realize that BIPA is a law and it exists. So that violation will likely be deemed more of a negligent violation. The statute says a penalty will be imposed of $5,000 per violation if it was knowing. The question here is, what is knowing? And of course, these class action attorneys who are bringing these lawsuits forward are arguing, well, at this point, employers should know about this law, and they should know that if they collect biometric information, they need to comply with this act. Part of the struggle with these types of lawsuits is virtually there's no defense. The law itself requires advance written notice and consent from the employees. If an employer starts capturing biometric information without giving that notification and consent in advance, that's a violation. That's a problem. And we struggle with how to argue around that as a defense. Last year, so this law has been around since 2008, and it wasn't written very well. And last year, the Supreme Court of Illinois had two very important decisions that create significant potential liability for employers under this law. One case decided what is kind of the length of time that an employee can bring a lawsuit under BIPA, because that was not clarified under the law. And the court ruled we have a general statute of limitations period of 5 years. The court said somebody has up to 5 years to bring a lawsuit under this act, which is quite a long period of time. The other issue that was decided by the Illinois case involved White Castle. So White Castle was using register systems where employees were scanning their fingerprints to kind of log into the register and I believe log out. And they did not have the required notice and signed consent by the employee to collect their fingerprint data. And so a class action ensued. The allegations of that class action were that each and every time an employee scanned their fingerprint, and they've got many employees here in Illinois, that's a violation in and of itself. So if you take that conservative $1,000 per violation and you multiply it by the number of fingerprint scans, by the number of employees, over a period of 5 years, White Castle was arguing that would equate to a potential liability for us of $17 billion. The Illinois Supreme Court said, yep, that's a lot of money, but the statute is clear. It's per violation. And so that is a potential issue here. And so the Supreme Court ruled that as the statute is written right now, a per violation means per scan, per capture of that biometric information, which was a very disappointing result for somebody like me who tries to defend against these types of cases for businesses. The good news, or the positive news for folks in Illinois, is that the legislature sat up after that ruling, and they've been working on an amendment to BIPA that makes it clear that a violation is actually one time, right? So the first time that a fingerprint is scanned, for example, that is the one violation, and a potential employee or consumer who has a claim under this act, they can only kind of assert damages either for $1,000 or $5,000. Now, again, this is still lucrative for class actions because even if you're dealing with, one individual who can claim $1,000 for liability, some of these actions have, hundreds or thousands or tens of thousands of employees at issue. So it's an area that we really want to get the word out with folks and make sure that they're complying with the notice and the consent requirements. And I just want to throw out a couple more examples real quick of the type of technology that might be using biometric information, just to underscore the need for employers to really talk with their business folks and understand what technology are we using with our employees. So obviously we've got the registers from the White Castle case. A lot of cases that have been filed have involved biometric time clocks. So scanning fingerprints or handprints just to punch in or out for your shift. We're seeing now more and more litigation over cameras that are installed in vehicles. Again, they're not cameras like surveillance type cameras, pardon me. They're more of cameras that actually scan some sort of facial feature of the individual to identify that that is the driver and then collect additional data beyond that. But again, the critical aspect here is biometric information. I know Sarah wanted to comment a little bit more about other states that may have biometric laws.
Sure, thanks, Ashley. So some of those state comprehensive data privacy laws that I mentioned earlier, actually, I think all of them do protect and consider biometric information to be, personal information, but they often consider them to be sensitive personal information or sensitive private information, which comes with it additional heightened criteria around protection, and in some cases actually requires consumers to opt in to consent to the use and disclosure of their sensitive personal information. Not quite as prescriptive as, at least initially, at least right now, the Illinois Biometric Information Privacy Act in terms of what needs to be in the consent, but they do require opt-in. So all of the 5 laws that are currently in effect, California, Colorado, Utah, Connecticut, and Virginia, they all consider biometric information to be sensitive personal information. And Colorado, the Data Privacy Act in Colorado does require that opt-in. So it's important to look closely. Obviously California is the law that applies to employee data, but across the board, if your company collects any biometric information from consumers, then there could be additional requirements as well. And then I also want to note, every state has a breach notification law. And many of them do specifically require notification to consumers when there's unauthorized, in some cases, access to, certainly unauthorized acquisition of biometric information. So it's important to just note that, even if you aren't subject to the state comprehensive data privacy laws yet, because your state has not passed a privacy law, those state breach notification laws do require notice, generally, if not all of them, but many of them, in the event that biometric information is acquired by someone who shouldn't have access to that information. I think we can go to the next slide.
Thanks, Sarah. And yeah, we can. And before I jump in on this next slide, I saw a couple questions in the chat. I will just emphasize, I think, and I get this question a lot, so security cameras that are set up at the work site, generally speaking, they are not collecting biometric information. So they're not, they don't function as capturing kind of personal characteristics of the individuals that appear on the camera, right? And they're not kind of identifying folks based on those personal characteristics. There is newer technology, though, that does do that. So, that is a worthwhile question to investigate internally with your business folks, is if we're just using kind of the traditional type of security cameras, that is not going to trigger BIPA. That is an exception because it's not capturing biometric information. However, if we're and all the time, I hear about companies where we're excited about some sort of new technology. It's kind of cool. We think it might be helpful. It might increase efficiency. It's just an easier way to track things, just like these biometric time clocks, right? And so let's make sure that when our business folks are exploring implementing new technology in the workplace, that we are thinking about BIPA. And again, the focus of today's webinar is employees and how this is impacting employees. Keep in mind, BIPA is not just employees. So again, if you're using technology for your business that impacts the biometric information of consumers, BIPA is going to apply to that technology as well. Just wanted to move on and mention another area where more and more states are passing laws to protect employees. And this involves genetic information and again, this particular example is based here in Illinois. Illinois is not the only state that has this type of law, but I wanted to point it out because I am very familiar with it. And this is a law, though, that is consumer-facing, not just employee-facing, so please keep that in mind. This law is called the Illinois Genetic Information Privacy Act, GIPA. So if you want an easy way to remember these two laws, BIPA and GIPA are what we commonly refer to them as. This is a law that is intended to protect individuals from having their genetic information used and or disclosed against them in a discriminatory way as it relates to employment practices. It does require written consent, and they define genetic testing and information derived from genetic testing within the law, and say it can only be released to individuals that the person subjected to the testing or the person whose information is involved specifically authorizes that in writing. We are just this year seeing a significant increase in class actions in Illinois based on this law. And it's the same law firms and attorneys who are pursuing those BIPA class actions. So we expect kind of a continued explosion because not a lot of folks are familiar with this law. How this law is impacting employers is if employers have a workforce, usually it's safety sensitive positions. So we've got employees where we need to send them for some sort of kind of pre-employment medical screening that's specific and needed for their position. So post-offer pre-employment screenings where we, as the employer, are contracting with a third-party clinic to do those screenings. Maybe sometimes it's coming up in like workers' comp screenings. But again, when some third party is collecting medical information about your employees, and then the third party is sending that medical information back to the employer, that's where potentially employers are violating GIPA or JIPA, because the employers are receiving that information and not obtaining a written consent from the employee to receive that information. So one thing that we've been talking to these types of employers about is, let's make sure when we're working with these third parties, let's make sure we review our contracts with the third parties and deal with this very issue. First and foremost, we as employers most likely and in most instances don't even want that medical detail, right? So for example, if the employee's kind of filling out the medical form talking about their family history and some of the medical issues or conditions that may have come up in their history, that's considered genetic information under this law. And so do we really as employers want that? Probably not. There's probably not even a need for it. So talking to our third-party vendors about, hey, our process is here are the forms we need from you, right? All we need from you is that form that says this person can perform this job, right? That's all we need back from you. And making that clear in the contract with the third-party clinic. Just to be really clear, if the employer receives the information, even though they didn't ask for it, they didn't request it, receiving that information without a consent, that's a violation of this law. And the penalties are similar to BIPA. We've got a $2,500 penalty per violation for basically a negligent violation, and then a $15,000 penalty per violation for an intentional violation here. So we think, those employers who aren't aware of this, again, we really are trying to get the word out to make sure that we button up our policies and procedures to limit exposure here. Moving on to the next slide, we wanted to take some time to talk about employee data, and I'm going to turn it over to Sarah.
Thanks, Ashley. So as I referenced earlier when I was talking about the California Consumer Privacy Act, one area that needs to be addressed in the privacy notices, as well as those privacy policies that go on your website, but the privacy disclosures that go to employees need to include information about consumers' rights and employees' rights with respect to the use, collection, use, and disclosure of the data. These are, this list kind of captures many of the rights that need to be addressed in those privacy notices, the right to, obviously this right to learn how your information is being used in the notice, the right to opt out of the sale or sharing of data. Sale or sharing, a lot of companies I work with initially think, oh, I'm not selling any data, which is probably true. They're not receiving any monetary compensation for the data, but they might be sharing the data in the way that the CCPA uses that term, in that they might be providing data to third parties that really are acting as service providers, but they don't have those contractual provisions in them that I mentioned earlier. Or if you are using certain types of tracking technology like Google Analytics on your computer, on your website, and individuals, employees or consumers are accessing your website, and information like IP addresses are being shared with Google, that does constitute sharing of data, and it does require provision of an implementation of the right to opt out of that sharing. Many times, a couple other Consumer rights that need to be disclosed are the right to access data, correct data that's incorrect, deletion of data, and just the right to know in terms of what categories of information are collected or shared with third parties. Those rights all have, exceptions and nuances to them. For example, you can deny a right to request for a correction of data if the information is accurate. There are also circumstances when you can deny a request to delete data if, for example, you have a legal obligation to maintain the data. And that often does come up, particularly with employee records, because some of the information needs to be maintained, for EEOC purposes, or, in the case of, potential litigation. So each of these do have nuances, but it's important to disclose to employees what those rights are. It's also extremely important to have a data subject request process. And one of the few areas that the CCPA currently requires trainings on is that anyone who's involved in handling data subject requests from employees or consumers needs to be trained on what's required under the law. There are very specific time frames with which you need to acknowledge the request. There's requirements in terms of how quickly you need to respond to the request. Is there audio issues? I see a couple of comments. Can you hear me?
It seems to be
Sarah,
working still.
I can hear you just fine.
Okay, well then I'll continue and hopefully that clears up a bit. So it's, this is an important area of the law and does require, certain internal facing policies and training, as well as those external facing disclosures to employees and consumers. I think we can move on to the next slide.
And I just want to build on, what Sarah outlined under the California law. There are other states that have laws about, employee information. Now, a lot of this information is actually owned by the employer, right? So this is not necessarily employee-owned information, but information that belongs to the employer involving their employees. And there are a lot of states that have their own laws pertaining to, I'll just call it colloquially, personnel files. So again, I'm going to use an Illinois example, but please note, there is in almost every state some type of law similar to this Illinois law, and they do vary quite a bit in terms of how the laws define personnel files, what can be in a personnel file, what should not be in a personnel file. Just a real quick refresher, we want to make sure that medical information about employees or their dependents are not in an employee personnel file and that they're stored separately in their own kind of area. But Illinois has a Personnel Record Review Act. It defines, when an employer is required to provide the employee a copy or make available for copy their personnel file. And it also defines what goes in a personnel file, what information is part of an employee's request for their personnel file. What's buried in this law that I'm not sure a lot of folks realize is a requirement for an employer to provide written notification to an employee before divulging a disciplinary report, letter of reprimand, or other disciplinary action to a third party. So, for example, a lot of personnel files that I review before they go out the door to an employee who may have requested it, or maybe to opposing counsel if they're looking into a potential claim or we're negotiating a separation package for an employee. They'll request the personnel file, and in that we've got maybe some emails, maybe a performance improvement plan, maybe we've got some sort of other kind of disciplinary action documented in that personnel file, which again, that's a great practice to have. I highly encourage all of us to make sure we're documenting performance issues and disciplinary issues as they arise. But under Illinois law, we want to make sure that we're complying with this requirement. Obviously, if an employee is requesting their personnel file, they're going to give us that written consent. Where this comes into play is all the time I see subpoenas come in the door to employers. And a lot of these cases involve, maybe a divorce where your employee is getting divorced and the opposing attorney for the other spouse is requesting the employment file, hoping to find information about how much they're getting paid, and so they're requesting the quote unquote personnel file. So this would be a third party where the employer needs to provide written notification to their employee if they're divulging disciplinary information. Now, again, some employers will just provide, we're not going to send you disciplinary information for that particular subpoena. There's really not a need for that in that circumstance, but just be aware of it. And most states have a law like this. So we want to make sure that we're complying with kind of the nuances amongst the different jurisdictions. One thing I also want to bring up very, very briefly is that in some circumstances, HIPAA may apply to certain employers. Now, I don't want to, get ahead of myself too much here. Generally speaking, HIPAA does not apply to employers, but for some employers who are administering their own health plan, so their own self-insured health plan, that might be a situation where HIPAA applies. So just keep that in mind. And then finally, I just wanted to mention very briefly the Fair Credit Reporting Act. So a lot of us are familiar with that law. There's the federal version, and then quite a few states have a state version, including California has its own kind of notice that's required for California employers when FCRA arises. So, just a quick refresher for us, because I do see this as an area where employers are maybe not complying with the FCRA. Before an employer obtains a consumer report, they have to inform an applicant or an employee that they can use this information from the consumer report to make an employment decision. So there's kind of a standard disclosure that the federal rule provides for. And then for the state ones that are a little bit different than the federal version, generally speaking, you can find those form disclosures online. We also need to make sure that we're obtaining written permission to employees and applicants before we obtain that consumer report. And then if an employer is to make an adverse action based on the consumer report. So for example, we run our background check, the background check reveals an issue that we're concerned about, enough so that we are going to send a job offer to an applicant, then there's a whole procedure we need to follow, right? We need to provide them notice, a copy of the consumer report, a copy of a form called a summary of your rights under the FCRA. We need to give them an opportunity to kind of rebut that. And in my experience, there are often many instances where the consumer report is incorrect. It's got the wrong person. And so providing that applicant or employee an opportunity to rebut the report is really important. Keep in mind too, in some circumstances, so a consumer report, let me just give you a quick overview of that. It's any communication containing information about, and I'm going to just say employee, creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. So it's not just like a background check on credit, which, by the way, you should be careful about in many states. It's really any sort of background check, and it can also cover drug testing. So if a drug testing laboratory directly provides results to an employer, that generally is not a consumer report. But if the drug testing company is working with some sort of kind of background check or credit reporting agency that the employer is using, that usually does invoke FCRA compliance. And we can move on to the next slide. Okay, artificial intelligence. This is a huge area that we're all going to see dramatic changes in the coming years. The laws and the regulations so far have not caught up with the technology, but they will soon. And we are seeing more and more states, federal agencies, and generally speaking, legislatures, even at a local level, implement laws that deal with AI. For example, we've got the Federal Trade Commission, who has made it clear in a regulation that, you know, certain restrictions on those who are developing AI and their responsibilities over how that AI is being used. Another area that is impacting employers more specifically is the EEOC. So the EEOC has published numerous guidelines about obligations that employers need to follow with respect to making sure that the AI tools that they're using and implementing are not discriminating against individuals. And there are actually a lot of examples of new technology that's been developed and actually stalled out because the developers have noticed in testing that these tools are biased against certain individuals. There was a tool that I think Google had developed a few years ago that they actually stopped from being launched because it had a bias against women. And so we're seeing lawsuits. There's a lawsuit referenced here about an individual who applied for a number of jobs online. The kind of application portal, he claims, the plaintiff claims that rejected his application even though he was qualified, and contained all of the kind of, his resume had all the great qualifications for the job description. He has an active lawsuit, and I just looked up this iTutor group lawsuit. It's still pending in court. The original complaint was dismissed by the judge, and the plaintiff filed an amended complaint just a couple months ago. So this case is still very much active. And he's alleging that the programming of its online recruitment software automatically rejected older applicants. So it's discriminatory based on age. New York City implemented a brand new law. The law was passed in 2021. There was some delay in the implementation to allow for regulations and rulemaking to come out, but it did go into effect July 5th of last year. It prohibits employers and employment agencies from using automated employment decision tools, right, AI, unless the tool has been subjected to a bias audit within 1 year of the use of the tool. The information about the bias audit is made publicly available, and correct notices have been provided to the job applicants or the employees. So New York's leading the charge here, but we definitely expect a lot of other jurisdictions to come forward with laws similar to this.
And one additional one additional lawsuit that I just want to mention is the FTC, the Federal Trade Commission, recently announced an enforcement action against Rite Aid in a case that kind of implicates both biometric information as well as AI. And in that case, you know, they were using facial recognition technology as part of their surveillance system to try to identify individuals who have committed, you know, shoplifting in the past. And it was super flawed technology, from, at least it sounds like it, from the complaint. And it basically alleged that Rite Aid failed to take reasonable measures to prevent harm to consumers from its use of that facial recognition technology. So I think that's just, you know, kind of brings up the biometric information and, you know, the care we need to take with that, as well as sort of the use of AI. But go ahead to the next slide. Thanks.
Yeah, and that's great, Sarah. And just very briefly, a little bit more information on the EEOC. There's another case cited here involving a screening tool, right? And some bias against African Americans as alleged in this lawsuit. But just to reiterate, the EEOC does have technical assistance on what it expects businesses to do when they're evaluating and using these AI tools. They want to make sure that the tool is related to the job and required by the business, right? So something that is definitely helping the business do its work. They want the business to be responsible for vetting the kind of the tool itself and making sure it's talking to the vendor that it's either purchased or licensed the tool from, to make sure that they've gone through kind of these tests to ensure that there isn't discrimination going on. And the EEOC guidance has made it really, really clear that even though the employer's not developing and building these tools, in most instances, the employer will be liable if there's a problem with the tool. So, we just want to reiterate to businesses to make sure that they are vetting these tools, that they're talking to the vendors, and that they're doing some sort of kind of annual check-in to make sure that, there's not some sort of kind of bias going on when they're using the tool. And we can move on to the next slide.
And this is just a cartoon that I think is really apt. I think, obviously we're all trying our best to be ethical and to do the right thing, but oftentimes we're not even aware that the actual platform is programmed in a way that often and likely probably is unintentionally discriminating against classes of individuals, and that can lead to obviously a lot of legal complications that we all want to avoid.
Okay, so on the next slide, just a couple of points about laws that have been implemented, especially in light of remote working, of employee monitoring. So just two examples here. We've got laws in both Delaware and Connecticut that requires employers to provide notification to employees in the event that they're doing electronic monitoring. And that requirement is before they actually do the monitoring. Under the Delaware law, it's interesting, the employer has a choice of either a one-time notification, so long as the employee acknowledges receipt of that in writing, or alternatively, every single time, once per day, I should say, that the employee is accessing some sort of technology that has electronic monitoring. And what we're talking about is really computer usage, internet access, emails, telephone conversations. Connecticut's law is very similar to Delaware's. So if you're using any sort of technology involving monitoring employees' use of computers, internet, and making sure they're working when they are working remotely, please keep in mind that more and more jurisdictions are passing these laws. We can move on to the next slide. And very briefly, I just wanted to reference many states, most states, have some sort of protections prohibiting employers from trying to request their employees' personal social media account information. So username, passwords, other credentials for trying to access that information. Some of these laws have been around for a while. Hopefully folks know about them, but we just wanted to mention them briefly. All right, Sarah?
Sure. So I'll be quick. I know we only have one more minute. But, a lot of companies, we covered a lot today. And a lot of companies that I talk to, they're just like, I don't even know where to begin. And I think that, sort of the first place to begin is really assessing which laws apply to your company, kind of doing a high level gap analysis to identify, okay, these are the policies and procedures I have in place. this is what I, have in terms of contracts. Where are there significant compliance gaps? And then putting together a plan that prioritizes steps that will help you to address those gaps. I mean, at a high level, I think that's a great place to start. This slide really kind of talks about the importance of building out a data security and privacy program, and there are, we can certainly kind of talk about different policies and procedures that are industry standard or required by the laws that apply to you. But that's really what I suggest in terms of tackling sort of this area that really does require a lot and is evolving quickly.
And I would just add very briefly that along with what Sarah suggested, in terms of employment practices and policies, we highly recommend organizations review annually their policies, what's changed since the previous year, what new technologies have we implemented as an organization, and determine, what requirements might be triggered in the places where we are conducting business. And just make sure to do that on some sort of regular schedule.
Awesome. Well, thank you so much for joining us today. I think we're out of time, and go ahead. Sorry, Ashley, what were you going to say?
No, same thing, Sarah. Just thank you. And we're out of time. And these are the HCRI and SHRM codes if you're seeking credit there.
Awesome. Well, thanks again for joining us. If you do have any follow-up questions, don't hesitate to reach out to us by email. Thanks. Bye.